Good morning, everybody. Thanks for being here.
Good morning.
Morning.
Where is it? Let's grab our people.
A little bit. Yeah.
Okay,
Gather
so
around. Gather around.
we're going to quickly go through our announcements and stuff because we have our esteemed Elaine Mueller with us today. Okay, how about a joy share? I think Tracy has joy.
Yeah, I had so much fun. I had a little client party this weekend. It was super easy. I hired Vicky Lips ice cream truck to come to the Southeast office. And I invited people that I hadn't seen in a while that I really wanted to see. I invited some people from business to me, so it wasn't like I didn't invite everybody. I just invited a few people that I really wanted to connect with, and that was really different than I do a big party every year. So I'm starting to introduce some smaller little parties. And it brought me a lot of joy just because I got to really talk to people as opposed to feeling like I was like, oh, I gotta go say hi to this person. Like I actually got to really connect with them and hear about their kids. And I wanted to share that too because 50 Looks is like totally up for doing more of those. And it was easy. I did almost nothing to prepare. So it was really good. Yeah, and I think I had about 60 people there, and everyone was so happy. We had really good, doing sidewalk chalk outside. And it was just really, it was great.
Can I ask how much it costs to have 50 Looks come in?
Yeah, it's $5 a cone. And they have a 75 cone minimum, but they'll send you home with the rest of the ice cream. I got this home with 5 pints of ice cream, so I had 10 cones left. So, yeah, so it's good. And I think, too, when you do something special like that for somebody, like 50 Looks, or I don't know if Salt and Straw does it, but in Portland, people were like, I'm so bummed I can't make it, like they were out of town or whatever. But even the thought of them getting an invitation, even if they don't come, it has the same impact with people that you invited them. So I just wanted to share that. If you want to do something super easy for a client party, that is amazing. In Southeast, it's shady in the afternoon right in front of the office. It was like picture perfect. It was really awesome. Even if it was hot, it would have been cool to have people go inside.
Thanks, Tracy.
Yeah.
Jim, did you have a little joy share today, too?
I decided to celebrate my 50th year in business by doing something that would allow me to touch each one of my past clients. So I spent a truckload on table glass that were custom engraved with a living room logo and my new logo, and it's been a hit because I had the opportunity to hand them personally to past clients and do it with table glass. And so it's done a number of things, giving me an opportunity to speak to everyone individually, catch up with people I haven't seen in a long time, and it's also something that I actually try to hold on to, and I get free branding out of it. So it brought me joy.
How are you doing your delivery? Like you drop by?
One by one, and take off.
Calling it first?
No. Cool. That's going on really well. And then I had a class for hours amazing grade. I say thank you for the logo, and so I've been giving those full of beer as part of my housewarming gifts.
Where did you get them?
There's a company down near Hubbard in the middle of nowhere who does most of the engraving for that class. And so I found them just Google searching.
I need to upgrade.
Oh, it's a good one. Yes, engraving is free. And it looks like something
It's really beautiful. I saw it. It's beautiful.
Yeah, it's gorgeous.
it looks really good.
All right, cool. Thanks, Jim. Do you have a joy?
Well, it's sort of a joy, and it's also, you guys saw my email, I'm Yonette Pine. I'm a realtor, but my night job is I own a winery vineyard called Cerulean. And I sent y'all an email that was suggested that I mentioned at the meeting that my joy is we're moving our winemaking facility you guys 20% off of our case prices. So I realize there's a lot of people here. I just brought up a sheet. You can just photograph it if you don't have the email. My email's at the bottom. You can hit me up for cases. It's great wine. It's really great wine. It's going to be, it takes about a week because they're newly released. So you guys are getting our new releases. And then it's done. We're not going to offer 20% off case because it's wholesale price. It's 20% off the case, wholesale price. So it's super, super great for client gifts.
Thanks. Thanks,
And
Trina.
you're-
Yeah?
Thank you.
Gavin? You got an announcement too?
Yeah.
All right, quick, come on.
The Earth Advantage is putting on a home energy score webinar, and it's going to be this Thursday, and then I think we'll do another one next week. But I serve on the Earth Advantage Realty Advisory Board, and they asked me to be the realtor person on the webinar. So I'm giving the webinar the first part. So, and it's free, and so you can sign up for it. You just go to your advantage. But it's all about the coming home energy score and what that program is going to look like from the student score level. That starts, I believe it's January 20th, and it will be mandatory for all listings. We're going to have to put together a home energy score for our listings. So it's definitely something that we all need to have on our radar. Yeah, fast. And so it's good to get kind of an idea of it. And like I said, but the first webinar is a live webinar. It's Thursday morning at 9:30. I should be more prepared. Hold on.
Can you send us a link?
Yeah, I'll send a link so you can send that to the
Thanks, Gavin.
Also, do you have credit hours? Just curious.
I don't know.
I think you do, because I'm saying that. Yeah.
Eleanor? Eleanor. Oh, there you are.
Hi, everybody. Great to see you. Madam, I thank you very much. I'm here today to introduce you to Amber Blum, who is our newest transaction coordinator. I got to hire Amber 2 weeks ago to help with the transaction demand that you guys are amazingly pumping through the pipelines. And so Amber has 6 years of transaction coordination experience in California, and I'm training her on all things Oregon, all things living room. So I'm stepping away from the transaction coordinator role so I can do more administrative support for the membership services team. And Amber is taking all of my beautiful clients under her loving arms and taking care of them. So if you are thinking about transaction coordination, you're thinking you're tired of your paperwork and you want somebody really talented to just like take care of it for you, this woman is ready. And I'm really excited that she's here. You guys throw the coolest office meetings I have. You guys are fun. But like Eleanor said, I have about a decade experience in real estate back home in San Cruz on my brokerage and 6 years in transaction coordination. So I'm very comfortable with the ins and outs of real estate sale. So if you need anything at all, I'm here. Ready for you.
Lauren, you had a quick announcement, didn't you?
Yes, you guys may have seen an email come out yesterday. We've got a volunteer opportunity. Our own Tony Lee actually brought this one to us, and it's a super fun one. It's outside of the living room. It's at Dornbecker, and you'll be serving food to kids there and their families. Sounds like a really good time. We've already got some people signed up, but we need 1 or 2 more. It's tomorrow evening. We'll send out the email again if you want to sign up, and you get a free living room shirt.
Thanks, Lauren. We have Jeff Dorn with us today.
My name is Jeff Dorn. I'm with Country Financial. I'm an insurance agent. Thank you for everybody who sent me referrals out of this office. It's fantastic to have my phone ring and be able to serve your clients. My phone number, by the way, is 503-888-4825. That's my cell. Call me if you have any questions. The last month, I had 2 agents call me and help me get a deal closed because the buying agents couldn't get insurance for a thing, and so I love things like that where I get to fly in, save the day, and make everybody happy. So I really appreciate that. So any questions you have about anything, call me. That's that. Couple of quick announcements. I mentioned about a year ago I wanted to do this, basically a music listening church or an album listening church. Well, that is up and going. We've done it twice. We did a Bowie album, the Clash album the last couple of months. And basically it's called AC/DC, which is an album, coffee, donut church. And we sit around and listen to an album on Sunday morning and we go about our merry way. It's a very relaxing and wonderful way to start the day. I also had a conversation with an agent out of this office about giving back to the community. My wife and I have been involved with feeding, I don't know, poor people. I don't know what the politically correct term is. Poor people who come in, about 100 of them, for a basically a brunch at the on Woodstock. There's a church on Woodstock. That's the first Saturday. If you've ever wanted to do any part of that, from buttering bread to serving food to doing dishes, that's the first Saturday. Let me know. And then I'm going to plug my wife's business, which is called Cook First. She's teaching middle school kids how to cook. She's got a week-long workshop, and basically July 31st and 4th, and then I think in the middle of August. And it's just a lot of fun teaching, helping kids learn how to cook. Anyways, that's it. Thank you very much.
Thanks, Jeff. Amanda, tour today? What's happening?
We are going on tour today, so if anyone wants to go, I have 3 very squished seats in my car. If anyone wants to come with me, or if somebody wants to drive, you will have to sit on cooking crumbs from children. And then on a side note, some of us are going to go float the Sandy River tomorrow, just for a few hours, not a huge float, but if anyone wants to go, we'll probably leave around 10.
Yeah.
So hit me up.
Where are you leaving from?
Dabney, and we'll
Yeah.
go to the Lewis Park.
Yep. Cool.
Well, and I was gonna say, that house is open, so if you guys
Just
wander
stop
up,
off.
if you decide to wander up there instead, and just remind her who you are, she's fine with
Oh my
it.
gosh.
She tells me all the time, she's fine with it.
Nicest people on earth.
And you can use that bathroom, they keep that door open.
I'm gonna save up.
Do you have any other drivers today?
What was that? Oh,
Sean's willing to drive?
Yeah, so I've got 3 seats in my car too. Going to go on tour shortly after the meeting, and then I've got it booked out until maybe about 11:30 or 12. So if you want to join me, you're welcome to.
Okay, cool. Let's see. Sorry, I forgot where I was going. How about tour? Anybody have anything on tour today?
I have something on tour. At 1:30 to 4:30, we're going to do bubbly white wine. And some really nice bites to eat. It's the Red Modern Farmhouse. It's really cool. We'd love for you guys to stop by and see it. It's a very unique property. It's worthwhile coming to stop by. Check it out. Christine and Patty Sue and I will be there hosting.
Anybody else? Jennifer?
I have a house in Laurelhurst on tour today at 3424 Northeast Multnomah. It's a 4-bedroom, 2-bath, Tudor. It's got the most gorgeous kitchen. I recommend just coming to see that. It's a gorgeous backyard. It's listed at $729. It was built in 1939, so it's got some really unique qualities about it. But they probably did about $100,000 plus kitchen remodel on it. It's absolutely stunning. It's in good shape. I'd love for y'all to stop by in your church tour and see me. And I'm happy to be there, so we won't go away.
Awesome.
11:1. And then, little flyers floating around the kitchen corners.
Yes, Terry?
I want to talk about a couple things on tour today. First one is 2620 Northeast Lombard. I'm going to let Bobby talk more about it, but it's a fabulous fourplex. You really should get by today while he says to get open, because there's going to be a tenant in there by August 1st. This is your chance to see inside this really awesome 6-room fourplex.
a couple of years while we're doing some renovations that we're doing in the house we later bought. But it's a really great, profitable fourplex. We've done a number of updates over the past 4.5 years, including a brand new roof that was just put on this month. This month. It's fully rented. It always rents out. It's 2 blocks from Newport University. You can call myself or Terry if you have questions.
The price is $785. It's a zone R2 on a 10K lot, so we're going to put 50 in it there. They have done lots of consistent updates throughout. They have one long-term 18-year tenant there. It's fabulous, not a hoarder. Each unit is 2-bedroom, 1 bath, 748 square feet. There's hardwoods under all of the floors there, and some have been exposed. It's really cute. The vacant unit is staged right now. Honestly, you guys, get by there today. It's like 4 minutes from here. There's no excuse. Get by there. I'll be there from around. Second tour item, we have a listing at 4136 Northeast 135th for $369. This is an RV terrace, 3/4 century with a floor living on the back. It's awesome. It's totally skylighted room on an 8-size lot, 2188 square feet. That will be unhosted today, but if you go by and use the wrong box, it's going to be a copy card. It's 4136 Northeast 135th. Cargo's off shaper. 369. And then we have one in Sabin today at 3826 Northeast 9th. That one is $570,000. Totally studs out, foundation, everything in 2008. That's vacant on lockbox. It's a fabulous 3-bedroom, 2.5 bath, completely updated kitchen, master suite. They've done a lot of 2017 updates, including the kitchen, French doors to the backyard, interior ceiling on the front porch, et cetera, et cetera. That's taken on lockbox and very nearby. And it's flying a little under the radar, so we'll take a look at that. It's really a great house in Sabin. The address is 3826 Northeast 9th. And then Reg is hosting one today at 4795 North Amherst. That just came on the market yesterday. That's the University of Portland custom craftsman with an ADU in the basement, fully permitted. Great investor, owner occupied. They've done a lot of custom details inside. Again, that upstairs master suite. The ADU is awesome, and Red will be there.
And that's 659, right?
659.9.
659.9. Great.
No, it's vacant right now. No, it's over on tonight.
Any idea what?
I don't know. I'm not gonna go out on that one. And then last but not least, we have our lab edition listing on tour today. And that's 1556 Southeast Elliott. That's coming on that's on at 829. There's just nothing else out there like this. There really isn't. Architect design. Yeah. He's like, that's the entrance portal. So you will enter a different world when you go there.
Does it require a magic wand?
Bring your cake, for sure. No, this place is hard to describe, but this family's been in there for 25 years. It's the architect owner in there. You will just see the love that they have for this space. gonna be really your only chance to do something like this anywhere, but especially in labs. It's 4 bedrooms, 2.5 baths. All the bedrooms are up, and all the bedrooms are connected to an outside balcony. And then when you get to the 3rd floor, it's a vaulted master suite with a balcony on either side of each end of the suite, and there's seasonal views of downtown. Every room has tons of built-ins. There's tons of curves throughout this building, and all kinds of tapered walls and windows. I mean, it's just awesome. You should come by just for fun, because that's a really fun listing. I'll be there with food, crudité made by Percy, and drinks, and you might get a glimpse of Percy as well. 11 to 1. Come by.
Thanks, Terry. Erica?
We've got out in Pleasant Valley, we've got really, really awesome eating, one-level ranch for the babies for $3.95. It is well maintained, it's beautiful. Lots of sort of custom updates. It's right on a turn. It's got beautiful outdoor living, 3 bedrooms, 2 baths, and it's just it's you know for under 4, and it only takes less than 20 minutes to walk up. So, 12 to 2 today. Come see me outside the food. So, and it's a little loud. You'd be surprised how great it can be.
Thanks, Erica. Stacy? Do you want to talk about Kristen's?
Sure. We have a little 1-bedroom on the corner of Tolman and 71st. It's about 725 square feet max. It's on a corner, so it's got a beautiful gardens, original hardwood floors, definitely a vintage kitchen, but could use your touches if you want to put it in there. A little oasis really in the backyard, a lot of ADU, with a garage. So a lot of potential, 285.
What are the major crossings?
It's 71st and Tolman, so it's just 1 block south of Woodstock. Yeah, just literally 1 block.
Are you there today?
Kristen will be there 11 to 1, grab and go food, so check it out.
Awesome. Thank you. Okay, one more quick announcement, and then I think we're going to jump over to Lane. We have the Division Clinton Street Fair this weekend, Saturday, and then mark your calendars, you guys. We've got that. The street fairs are so awesome. They bring in so many people. It's a great opportunity to kind of connect with the community. We have that this weekend. We have the Alberta Street Fair on August 12th and Multnomah Days on August, I erased the date. I don't know what that is, but it's after the 12th, I think. But join us. We do a parade. We've got a house you can wear if you don't want anybody to see your face. It's super fun. Aren't they super fun?
They're super fun. And if you have a bus bench anywhere on the route, I don't know if Dale, she's here, but like last year, I wish she had been in the parade because all the kids came running looking for Dale.
The lady on the bench? Where's the lady on the bench?
I know.
I'm here.
Like,
Yeah, the lady on the bench.
Oh, you're here. So,
Alyssa?
But I am working the fair. I'll be in the booth at some point, scooping ice cream like I do every year.
Good.
Perfect.
Alyssa, did you want to say something?
We just need a couple of more people for specifically the parade, which starts on 11. So we'll be down there just headed out with people with their children, holding banners. This is great. Bring your dog children. Like, let's do this.
I wore it last year. It was super fun.
Yeah, we're all gonna be there.
Kids can be on their bicycles and wagons and.
Did you just say bring your dogs? Yeah. Okay, I think dogs can't bring dogs. Yeah, they like banned it a couple years ago.
Someone brought their pig last year.
Yeah,
I worked That's different. Maybe your cat.
All right. Okay. I think we're running a little bit late. So take a look at the board at some point. I think it's interesting that pretty much all over the city, things are either selling at list price, maybe a little bit under. We've got one in Gresham that went 3.5 times over, which is interesting. So I like that first one, lazy seller's agent. Okay, but let's turn it over to Lane since we are running a little bit late here. Welcome. If everybody close your laptops, great.
Morning.
Morning, Lane.
Morning. Wow, Janelle, you guys have grown exponentially. I mean, I knew you had grown exponentially, but what a sharp looking. You guys really are pretty sharp looking. Your eyes are open, you know, you have a smile on your face. You're looking good. You're looking good. Keep it up. Keep it up. Okay. Well, I'm going to have Alyssa help me with this because she's our little whiz for the PowerPoint for you. The topic for today is the hows and whys of covenants and contingencies. And what I'm going to do is I'm going to go over those. You know, writing addenda is the last area you can actually practice law without a license. So it's always kind of exciting. And the thing that's always interesting is that, you know, writing law is incredibly, incredibly word intensive. I mean, we've had legal cases up to the Supreme Court turning on one word or the positioning of a comma. So what you write is really important, okay? So we want to get this down because it's not that hard. There's a little formula and we can get you to do it. And my God, you're going to look brilliant. And I'm sure many of yours do. You will see some examples of ones that I picked out at random. None of yours, to my knowledge, but ones that I picked out at random and kind of went, wow, we need help. All right. You know, the thing that's curious more than anything else is that the majority of all clauses that are drafted are covenants, promises, rather than contingencies, probably about 98% of them. And so it really begs the question then, what's the difference between the two and why do you choose one over the other? Okay? And what I'm going to do is let's take for instance a question. I'm going to ask you to go to then I am in my glory. All right. If you could switch, where are you? Lisa, will you, there we go. Back one, there you go. Let's take, okay. I think this is a thing from going from my little laptop, which is, to Mac. So this will be interesting. So that is your eyesight, in case you're wondering. It's clear, okay? But let's take it let's imagine for a second. What we have is we got a statement that says the seller replaced the roof by closing. Okay? Sounds like a reasonable comment. And the question is, what is that? And what you know is that is a covenant. It's a promise. The seller is saying, I promise to replace the roof by closing. That's what he's saying. And the purpose of promises are to bind a party. You want to keep them in the transaction. That's the goal. And usually what we do is we have what's called command language. And under the law, what you will see very often, if a lawyer ever gets a hold of something like this, is it wouldn't say seller to replace the roof. It would say seller shall replace the roof. Anytime you see the word shall, that is a directive of what somebody must do under the law, okay? Now, it begs the question then, how do we know that we write a covenant? I mean, what would prompt us to think that that's the appropriate thing to do? And what you do, it's a very simple question. You say to your client, the buyer, you say, hey, if the seller fails to replace the roof by closing, as he promised, do you still want to buy the property? And if the answer is yes, you've got a covenant because he wants to bind that seller. Okay, he wants to bind that seller. He says, I want this property, but I also want the opportunity to go after the guy if he fails to do what he promised. So if you fail to do what you promised, that's called a breach. And there is certain recourse of that. There's certain consequences, which then raises a bunch of questions. If the seller fails to replace the roof by closing, you get to the closing date and there's no roof, what are your buyer's options? Okay. Well, the first thing I want you to know, the general rule about covenants is that if you break a promise, you can be sued. It's about money, okay? And that's across the board. You can always sue. But what happens if your buyer turns to you and says, you didn't put the roof on there. Do I still have to buy this thing? I want to get out. Can he get out? You think? Okay, it's going to depend. Don't you love that? This is why lawyers make money. Lawyers make money because of reasonable, satisfactory, we make up all these words that nobody says, what does that really mean? Then you have to ask, see? So anyway, it depends on whether it's a material breach or a partial breach. A material breach is a breach that's so substantial that it defeats the purpose of the transaction. So the question then is raised, is not having a repaired roof on this house so substantial that it actually defeats the buyer's purpose? I think arguably you'd say yes. I mean, most times when I buy a house, I think there will probably be a roof that functions. I mean, that would be kind of an important thing to me. So arguably you would say yes. If it does rise to that occasion, then that buyer not only can terminate, but he can sue for all the out-of-pocket expenses up to that point. So he gets his inspection fee back, he gets his credit, he had to do the credit report, the appraisal, whatever it was. He can get that money back, out-of-pocket stuff back. But let me ask you another question. Okay, so we know if he doesn't do it by closing, those are his options. Let's imagine for a second that we have, these are the dates. We're supposed to actually have the roof on. The roof is to be replaced by May 15th, and the closing is June 1st, okay? My question for you is, if he fails to put it on the roof by May 15th, can he terminate then, or does he have to wait till June 1st?
June 1st.
June 1st? How many say June 1st?
Is it the seller to place?
Yeah, same thing. But it's not by closing, it was by May 15th.
Okay.
And the closing now is June 1st. We got, you guys are so chickeny. How many say by May 1st, May 15th? I'm getting you a little braver. That's, okay. Okay, breaking a promise is breaking a promise, okay? If you break a promise, you have the recourse on May 15th, all right? You don't have to wait until June 1st. If somebody breaks a promise, if I break my promise to you, I can't hold you hostage for 2 weeks, okay? So I would have the same recourse that I would have. I would have the choice at that point when there's a breach. What I can do is I can say, and I consider it a material breach, I can say, I'm out of here, I don't want to buy this thing, you reimburse me for the money. Now remember, when we're doing covenants, this is going to be compared to contingencies. When we're doing covenants, these are lawsuits. Because you know the other side is going to say, well, but I have a defense, right? But what I'm saying to you is, yeah, I can raise the thing if I'm the buyer and say, look, you didn't do it by May 15th, I can walk away and you owe me the money. That's going to be my claim against you. Or I can wait until June 1st, close, and then sue him for the money, sue him for the cost of replacing the roof, which I now have to do. Not a great option, only because just because you win a lawsuit doesn't mean you collect money, right? Now you got to go collect. Now you got to go, you have to go garnish the guy's wages, you got to go through, you got to go through all that stuff. And so, not always the best option, but there you are. Let me ask you another one. Let's imagine for a second, another scenario. What we have is we still have the May 15th, they're supposed to put the roof on, and June 1st is supposed to be the closing date. But what happens if the buyer on May 1st says there's no way in God's green earth this guy's going to get the roof on? He had to apply, whether he had to apply for a permit or it's raining out or whatever the thing is, there's no way this guy can perform by the 15th. Can the buyer walk away on May 1st, or does he have to wait till the 15th when the roof was supposed to be put on? Have to wait till the 15th. Sometimes. Okay? Now, just because we always have fun terms, and like medicine. I have a friend of mine that's a doctor and also was in the Air Force. Can't understand a word she says. I have no idea what all that language is. I just keep nodding. Figure if it's bad, she'll poke me. Okay? So, in law, this is called anticipatory repudiation. God love it. What you're doing is you're anticipating that somebody will not be able to perform on time. That's what that exciting term means. It's not one word, by the way. Never mind, I won't go into that story. But anyway, it's 2 words. As a little kid, I heard a word and I thought, wow, it's big. My mom used to tell me, what was it that I have to, oh, I had an elegant sufficiency. I told her I was full. And she said, oh, you mean you had an elegant sufficiency? So I'm 5 years old, and I run out and tell all my friends, you think supercalifragilisticexpialidocious is that long. Wait till you hear this word. And I thought it was one word. But anyway, that's why I'm saying anticipatory repudiation is 2 words. Okay, so what happens is you can anticipate, that buyer can anticipate and demand further assurances from that seller that they will be able to perform. If the seller can't provide reasonable assurances, that would be reasonable to all of us, that he actually would be able to function, perform his duties by May 15th when he's supposed to, can walk away on the 1st. Okay? So, now, let's get off the roof for a second. Let me ask you another question. Let's imagine for a second that what it is that the buyer promises to seller promises to provide garden tools at closing. And you get to closing and there are no garden tools. What's the buyer's recourse?
Small claim.
Small claims. So you can sue. You can sue them, right? You can sue them for not providing them. Can I terminate?
No.
Why not?
Partial.
Oh my God, good for you. Yes, it's a partial breach. Truly, did the person really make an offer on the property just because they wanted the garden tools? I don't think so. I think they were thinking about the roof, the electrical, the plumbing, the moving in, where the couch is going to fit, all that kind of good stuff, right? What if I up the ante? What if we're out in a property that literally the structure has absolutely no value? So in effect, what we have is we have vacant land, and part of the deal is I'm getting a $50,000 tractor. Guy drives off with the tractor. Do I get to terminate? It's personal. Yeah, the problem is, did you really still, the value of the land is probably going to exceed the $50,000 tractor. Although you wanted to buy the tractor because you needed to, whatever people do on land with tractors. So you needed to do that, right? You need a till or whatever they do. So anyway, you need to do that. If it's under the sale agreement, that's how you would sue under the sale agreement. So if it's included as part of the purchase price, that's where you would sue. You're still going to sue. Or if it is actually, what you did is you got a bill of sale. So you paid for it outside of closing, you'd be able to sue on that contract. But you're still, whatever you're doing, you're suing on a contract. Okay? All right. That was fun. Now you know what a covenant is. Let's go to a contingency. Ah, these are wonderful. It's like 2% of all all drafting includes a contingency. It's amazing. And not that you should use them all the time, but they are a great tool. And you'll notice that the definition of it is a little longer than just one word. It describes an event that may or may not occur, but has to occur in order to require the parties to perform. In simple words, think of your financing contingency. It says if I'm going to go borrow money to buy a house, and I can't qualify at no fault of my own, okay, but I can't qualify for the loan, what happens? Can I get sued? No. What do I get to do? I get to walk away. I get to walk away. So the purpose of a contingency is to give your client an out. And there's contingency language. Under the law, under Oregon law, all clauses are considered to be, they're deemed to be covenants unless you tell us otherwise. So you have to make it very clear when you're writing a contingency. But if there's no terrible, difficult magic language to it. That's where you see the subject to, contingent upon, any conditional language, conditioned upon, provided that, if, in the event. What I'd like to encourage you to do is use either subject to or contingent upon. And I'll explain to you a little later in a case where you just don't want it up for a question. You want to make it very clear that that's what you're writing. So it's subject to, if what you would write is it's subject to the seller repairing the roof prior to closing, right? Now you have a contingency. Not a great contingency, but you have a contingency. And so, and why I say great contingency is because what happens, there are elements, not only in a covenant, but also in a contingency that you follow. And if you include all those elements, there's 5 in a covenant and 8 in a contingency. And it's literally filling in the blank. This is not difficult, but you have to go ahead and address every one of them, because if you don't, they're going to be a problem. The operative question, remember with a covenant? Hey, if the seller doesn't put on the roof that he, as he promised, you want to buy, and the guy said, yes, that was a covenant. If he says no, that's a contingency, because he's saying, I don't want the property unless I get my roof. The other guy said, I want the property even if he doesn't put the roof on, and I'll sue him, right? But I still want the property. So that's that. If a contingency fails, the parties are excused from having to perform. So if I, no fault of my own, can't get my financing, I don't have to buy, okay? Not only do I not have to buy, I get to terminate and I get my earnest money back, right? According to the contract. So those are the consequences. I do want to repeat for you. I want to let you know, okay, this is contingencies create a unilateral right, okay? Think of your inspection contingency. I have a unilateral right to get out of this transaction if I don't like what that inspection came up with, right? I don't have to ask anybody. I have a right to get out of town. And all I have to do is notify them. And I get to walk away. And I want you to know there's a procedure to this. So there's like a little 4-step procedure. Very simple. But what you do is if you're, let's imagine during the inspection period, because that's the one you guys are most familiar with. During the inspection period, your client says, I don't want to buy this property. There's just way too much stuff wrong with this thing. So they want to terminate. What you need to do is get something in writing from your client saying, I don't want to proceed with this transaction. Because what I've seen before is you get that verbally from your client, you tell the other side your client doesn't want to proceed, and then your client says, well, I didn't really mean that. Oh God, now you're in the middle of that mess, okay? So get it in writing from them. And then go ahead and notify the other side. I don't care if you do it in an email. I don't care. Just don't do it on an addendum, okay? But you notify them. What I would do is I would first call. So you got the notice from your client. You then call the other agent because it's a small community. You want to keep your relations going. And saying, hey, Joe, I'm so sorry, but the inspection just came out worse than we had anticipated. The buyer's not comfortable. And he's going to be, I just want to let you know, he's going to be unconditionally disapproving. And then what you do is you send, like an email works great, little email saying the buyer exercises right to unilaterally get out of the contract based on the inspection report. And, I don't know if you have to say it this way, but in accord, what happens is that, the buyer is hereby terminating with all earnest money promptly refunded to the buyer. Whenever you say someone's going to terminate, please include the money, okay? With all earnest money. What are you going to do with the money? And you need it for 2 reasons. One, you need it to protect your client, but the other one, you need to help poor escrow. They don't know what to do with the money, right? So now they're holding it. They don't know if it's in dispute. They don't know what. So, and then you send the termination. Okay. The reason I said the email rather than an addendum is who signs an addendum? Both parties. So if I send an addendum informing someone that I want to unilaterally get out of a transaction, I am actually legally, arguably, from a legal standpoint, waiving my right to unilateral termination and asking for the seller's approval. Because that's what addenda do. They have, in order for an addendum to be binding, you have to have both parties sign, right? Can't have one person sign. Yeah.
There is the unconditional disapproval form.
Yes, and you should use it. You should use it. But I want you to know it only applies to inspections, right?
Yes.
So you gotta know how to do it outside of that. Okay. So, property disclosure. That's not only it. That's an unconditional walk away. I don't have to give you an excuse as long as that's the only. Earnest money. A title company or escrow can only release earnest money typically under 2 circumstances, either by mutual agreement of the parties or by court order, right? The property disclosure is the one exception by statute that allows the title company to release the earnest money without having any liability. And so it is if you have questions about a transaction, you can get out during the, property disclosure period. Rock solid. That fellow.
Yeah, quick, have you ever had to deal with that situation, having someone pull out of a transaction based on that kind of inspection contingency using an addendum and having that contested?
Mm-hmm.
Okay.
Yeah,
Just curious.
where the seller came back and said, no, I don't approve.
And then,
Right.
Well, I have your attention.
Mhm.
Can we go back
I
to-
only have a 2-minute attention span, so you gotta be quick. Yeah.
Can we go back to the tractor and the vacant land?
Yeah.
All right, so if they said on the contract that the tractor to be included of no stated value, could you sue for that if they didn't leave the tractor? Because there's no stated value, the tractor is no.
Oh, sure, because it's part of the purchase price.
Okay.
That's where it would fall under the purchase price. And you can actually write in there, now that I think about it, if that tractor were so important to your person because he says, look, I don't want this property without the tractor because what am I going to do with all this land that needs to be whatever they do to land? And you say, okay, then what we'll do is we'll make it clear that that is material to you. So this is the inclusion of this tractor is material to the buyer.
So it has that.
So now all of a sudden, well, it's material. That was really important. And now you have the idea that you can legally argue with a straight face that that is a material breach. You were put on notice up front, don't drive off with the tractor. Okay?
Isn't that sort of bring up lending questions? Because, if you're buying a property only for a tractor, essentially you're asking the bank to loan you money on a tractor.
But you're not buying it for only a tractor. But what you're doing is you're saying that part of it, that inclusion is so very important. You're buying the land.
But I think what he's saying is like if you're adding in with the tractor is of it's in average value of no stated in average condition of no stated value, then it's contractually it's a worthless tractor, it's $0. So how can you argue after the fact that they already paid anything?
Okay, you're confusing. At no stated value, what that means is that not that it's valueless, that it is part of the purchase price. Okay? So if I give you $500,000 for a property and it includes a $50,000 tractor as personal property, in that $500,000 was the value of that tractor. Now you're not really going to ever delineate that, but what it does is it allows you to sue on the basis of the contract, saying, I didn't get the benefit of my bargain. My bargain was supposed to be the land with this $50,000 tractor. You didn't give me the $50,000 tractor. I gave you notice up front that this was material to me. And that, I mean, you can even extend that further where you say this is a, this is a material inclusion in the offer. And if the tractor is not available, the buyer in their sole discretion may go ahead and terminate the transaction. I mean, you can go through about this stuff. I don't know how often you're going to run into that scenario.
There's a lender with his hand up behind you.
Yes, lender, sir.
I would avoid putting a tractor in as any value, let alone $50,000. It's pretty common to say for appliances to stay, maybe furniture or something,
Yeah. No, I agree with you. And we're not putting in there, I'm buying a $50,000 tractor. You know that, right? You're just putting in personal property tractor.
Well, they're saying they're worried that the lender will devalue the property because they're not going to lend on a tractor. Because the tractor can be driven away, it's not attached to the property.
But
So
it has.
it's a lending concern.
But it's not a lending, correct me if I'm wrong, but it's not, I wouldn't think it's a lending concern as long as it's part of the purchase.
No, because it would be.
Banks just want to lend on the property.
But all you're doing is including personal property. So why would that be any different than including a $20,000 hot tub, including why would that be any different? It's still part as is means that it's part of the purchase price, that it's included in the transaction itself. And it comes with the transaction.
I'll send an email out this afternoon with a little clarity.
Okay, well, good.
For everybody.
I mean, I'm fine to be corrected on this. I don't have a problem, but I'm not quite following why that would be. Now, I can understand if I were buying it from a bill of sale, and then I tried to terminate the bill of sale is going to be, clearly I'm buying the property and I'm writing a separate check for that tractor. And then it's outside the scope of the transaction itself. Interesting.
I'll sit down.
Okay, you go for it. Yes.
No, I was gonna say, you're saying that the purchase price minus the tractor is the actual value of the land. So
Well,
you're devaluing the land by.
No, it doesn't work like that. No, what I'm saying to you, what you need to understand is, I just want to make it clear to you, when you say at no stated value, the reason you say at no stated value is to include it in the purchase of the property, so it goes with the property. So when you close, the tractor's on the property, okay? I've seen people write before where they go and they write an addendum and they say it includes the tractor, and they don't say it, no stated value. Well, that requires a bill of sale now, because it's outside of the transaction. That's all that at no stated value, that's what that's saying. It's saying I'm including it as part of my purchase, along with my refrigerator, my stove, my garden tools, all the stuff. I get the farm tools, I get all that stuff. But it's not that you're looking at it and saying 500,000 minus 50,000 is I'm actually asking them to loan on 500,000 when really they're only doing a land sale, a land purchase, right? I don't know if you do land purchase. You loan on land by yourself?
Separate.
Yeah, no, not together, right? Do you loan on?
It's a separate loan.
Okay, but you do loan on land. Cool. Can you write me a check? Oh, be great. Okay. So, yes.
I have a really quick question about property disclosure. Say something gets disclosed after the original property disclosure. I've heard it both ways, that the timeline starts over, and then I've heard that that's not necessarily the truth, that once you get the property disclosure, the first time, it's a done deal, you get 5 days. But it makes sense to me that if something big is disclosed after the fact, that they would then have the 5 days to back out for something new that's been disclosed.
Okay, and they probably can, but you have to separate the difference between the property disclosure and disclosure. Those are two different things. So the property disclosure itself has its own period of time that it runs. If you discover something wrong with the property after the time of the property disclosure, the question has always been, do I have to revise the property disclosure and reinstate that 5 business day right of revocation? And the answer is no during that transaction, because you've been put on notice of the problem. And now it actually goes to whether you're getting the benefit of the bargain. Benefit of the bargain. So I'm paying X amount of dollars. It was supposed to be with a great roof. I didn't get a great roof. I didn't get my benefit of my bargain. So let's imagine that in the roof situation, the roof was fine until the storm came up, right? Well, you also have the provision in the sale agreement that you're supposed to have the property substantially in the same condition, so the burden falls on the seller to go ahead and fix that. If the seller fails to fix that, at that point, was this so egregious that you're buying a property with a blown off roof that you don't want to close? And if you do, the legal argument then, it's not about getting out on the property disclosure, that's over here, but it's getting out on the fact that I didn't get the benefit of the bargain. I didn't get what I bargained for. I bargained for a house with a roof, and I didn't get it. Yeah.
What if the disclosures are incomplete, like they didn't answer a couple of the questions, you have to send it back?
And they can walk away at any time prior to closing.
Okay.
Yeah. And that not only if they're incomplete, if you didn't include with the little asterisks where you have the explanation or the report, that's also not complete.
So then once.
So your job as a broker is to make sure your client, not help them fill it out, but make sure the thing's complete.
But then once it is complete, the timeline for 5 days doesn't start, then it just like goes.
It starts as soon as it's delivered, right?
Okay.
So the buyer's got to get it, right? So if I fill out a property disclosure and never give it to the buyer, they have until closing to get out unless I give them the property disclosure, right? So when you're representing a seller, what you want to do is get the disclosure. If they have to fill it out, get it out as quickly as possible. Because what you want to do as quickly as possible, if you're representing a buyer, is get out of all the ways that the seller can get out, right? We want to remove those. And if you're representing I mean, excuse me, you want to get, if you're representing the seller, you want to make sure you get rid of all the contingencies for the buyer, and if you're representing the buyer, you want to get rid of the contingencies for the seller. You want to get those out as quickly as possible, because once you do, and all those contingencies are gone, now it's just a matter of people performing.
So what if the buyer signs an incomplete set of disclosures? Are they signing off on it, or they're waiving the right to?
Can they go back later and go, oh, you didn't get this question, now we're leaving?
No, the point is was the disclosure complete? All your buyer is doing is acknowledging what you gave me and I got.
But what about if they never asked to complete the disclosure? That seems like something that
But
should.
the buyer doesn't ask to complete
Yeah,
the
like if
disclosure?
the buyer says, hey, this, if they never bounce it back, it's still incomplete.
Like they missed that a couple things didn't get answered.
Yeah, like they
And then
know,
the day
they,
before
they're
closing,
looking
they
it
found
over. Yeah, they see there's not, they never were quite.
Okay, an incomplete disclosure is an incomplete disclosure, okay? And even if the buyer later, you know, all the buyer is doing is acknowledging the thing. Did the time period start? I mean, clearly if the buyer wants to have some more information, they should ask for some more information. Because if the buyer doesn't revoke within that 5 business days, it's moot anyway,
So basically,
right? And they've accepted the partial property disclosure statement, right? They only have 5 business days to say, I don't like it.
I thought you were saying if there was claims or incomplete, then that.
They had it until closing.
Then it's open. But 5 business days doesn't start.
Right,
until-
correct, yes, I'm sorry.
If they discover at any point that the 5 business days, that something is incomplete, then they can ask you to complete it and the 5 business days starts over.
No.
Once you get the
Generally, it never was triggered.
It never was triggered.
It never was triggered.
But they start once you complete it.
Right. Huh?
Is it triggered after the buyer feels that it's complete and is satisfied with it? Is that basically what we're saying? So say there's incomplete, you have a question, you send it back, they ask you a question, you send it to you, that's when the date starts, because that's when it's triggered.
Okay, one of the things that's going to matter is whether the part that's not completed is really an important part. Okay? I mean, there's stuff on that property disclosure that, you know, yeah, you're supposed to check every box, but the thing doesn't apply. I mean, you know. So I didn't put not applicable. I mean, really?
Yeah, water
I mean,
rates.
you got to have, it's got to be some major stuff. I mean, it's got to be your sewer, your electrical, your plumbing, your.
Does the buyer have any responsibility or writing responsibility to verify every side that is incomplete, say the asterisk, the explanation page is missing, and they receive it? Is there any responsibility on the buyer's side to say, hey, you're missing the explanation page, or is it up to them to figure it out? Buyer back out of the buyer.
You have no duty to educate the other side. What the buyer's agent does have a duty to do is talk to his buyer and say, this thing isn't complete, what do you want to do? Do you want to just go ahead and proceed? Do you want to, you know, because there is a point where, you know, you have to be careful too. It's a little more complicated, but if the buyer never objects to the property disclosure, and then the day before closing says, oh, by the way, you never completed your property disclosure, and allowed the seller to detrimentally rely on the idea they had a transaction, like let's say the seller had to make certain repairs, put in another 10,000, did stuff, did custom things for this particular buyer, and then the buyer wants to get out on that basis, now we're into the good faith argument, okay? Well, you're holding out and you just want to stick it to me at the end? I mean, you know, you kind of, so there's all those different things, and what's really important about this, and what's all legal minds can, you can ask me, you can ask 5 other attorneys, and we can have 5 different decisions, right? The one that came up recently that was just, what is that thing? It was on, I'll think of it in a minute. But you can have people disagree on different things. So, and it's all going to get down to a legal argument. It's all going to get down to time-sensitive issues and specific to that case. Because if you've ever noticed, when an issue comes up and you go and you read the clause in the sale agreement, it depends on what the question is and how you answer. And it depends on who you're representing. So one of the first questions you always ask, you know, I'm sure Diane asks, is, you know, who you're representing, because it makes a huge difference. And if you know who you're representing, then you say, okay, how does this apply under these circumstances, and what are the surrounding circumstances? So the important thing is, the good news, you have a wonderful broker. Diane is one of the best, and I get to talk to her an awful lot. And the other thing is that she's smart enough to say, don't do anything, and don't make any decisions. And please, do me a favor, and do Diane a favor. Don't go out. I see agents constantly negotiate against themselves. We had 2 of these come up just recently. Unbelievable. Wonderful brokers. And what they did, we had a commercial broker. Commercial broker, long story short, didn't get his commission, right? So he wants the commission, and he's disputing about the commission. And the commission was $36,000. He talks to the attorney for the estate and says, if you pay me by Friday, I'll take 30. Now then he contacts me and I said, okay, we now know that he knows you're willing not to take 36. How do we're negotiating against ourselves. I have a friend of mine, Don, who's a wonderful attorney. And he's had this thing where he calls me up and he says, Lady, this is so terrific. I just sent a demand for $250,000. I said, great. And they said, no, I just received a demand from somebody for $250,000. And he says, I said, oh, you mean Kynes being sued for $250,000? He goes, yeah. And then 3 days later, I got a call from that same attorney and said, we'll give you $200,000. He said, I'm going to wait. They're going to owe us money by the end. This is terrific. It keeps going down. Okay? Don't negotiate against yourselves. And also, protect this brokerage, because without this brokerage, you all know you don't exist, right? I mean, that's how, and I'm not saying that from a mean standpoint. I'm saying that from the real estate agency. You have to be affiliated unless you hang your own shingle. Be nice to the brokerage and don't go promising money, because there's this legal theory of apparent authority that if you promise to pay somebody and you don't pay them, they're going to be knocking on Janelle's door. And they're going to say they promised on behalf of the brokerage. Okay? And we just had one of those. You know? I mean,
Why didn't he get his commission?
why didn't he get? Well, we're still working on it. We're still working on the commission.
Write it in, or was it
No, it's a long story about there was an option that was preceded this listing agreement, and did the option, was it really valid? And if it weren't valid, they never had a sale agreement, so did we have a prospective buyer? We don't know. I'm sitting there, I mean, that's why I didn't go through all that. I mean, it's kind of a long-tailed
We've
thing.
had a couple of those happen here in the house. Just, they closed and then the deal fell apart 2 days later, and then the commercial broker still wants their commission. It's like, well, there was no sale. Well, I got it to say. I mean, it just happens.
Yeah.
It happens.
And it happens a lot in commercial.
Yeah.
They're a little loosey-goosey. We have commercial people here? Yeah, loosey-goosey. You guys know loosey-goosey. Okay? No. I mean, it's kind of like, well, the rules don't really apply to you guys, kind of. And the nice thing is you got a real estate commissioner who is a commercial broker. So he says, nah, that stuff doesn't apply to us. So it's kind of a little loosey-goosey, but that's okay.
Well,
all right.
Too, some of the things I'm hearing, like, send out little red flags, because, like, I know you guys just want to know. Like, you just want to know, right? What are the rules? But the minute, the trouble that we always see is the minute you start hanging your hat on your right because you know the rules is the minute we know we're all in trouble. Because, like, I know that that I can get out because of this is when we know we're in trouble. So it's like, don't try to hang your hat on, I'm going to tell my sellers, or I'm going to tell my buyers, they can get out because they're incomplete. So don't worry, we'll go through the rest of the transaction and they've got incomplete. And then you find out, actually, that rule is not what you think, because once you get into core law, it's like, it's just up to the judge. So, like, again, like, the tractor belongs, it doesn't belong. Just listen to what she's saying as far as in the language, because that's what's important here. Not the tit and the tat. You're not going to do good real estate if you're going to outspox yourself and screw yourself. So anyway.
Right. And with deference to you, sir, I do want you to know that Janelle's absolutely right. There are all these different compartments to real estate, right? There's a lending compartment, there's a law compartment, there's an agency department, there's all these different compartments, and they all interact. That's one of the reasons why real estate is actually very interesting. I mean, there's nothing boring about it. And, and I tell people, do not act outside of your scope of expertise, Because if you don't have enough to do as a real estate broker, a real estate professional, my feeling is you ain't doing your job, because there's a lot of stuff to do, okay? You don't need to be a contractor. You don't need to, God save you if you ever loan money to your client. You don't need to be a creditor, because you can kiss your commission goodbye if there's a problem. It'll be gone, because that's a breach of your fiduciary duty, because now you're the creditor and you're going to, what are you going to do, sue your client? And we had one of those recently where somebody said, well, I'll just give them, I paid $1,200 and kind of, protect them. No, 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 no. No giving money away and no drawing legal conclusions, okay? Sell real estate. When people come to me and they say, Lane, what do you think? They'll ask me to write a land sale contract. And I say, sure. And they say, well, do you think it's worth it? Ah, that's a real estate question. That's a broker question. That's not a lawyer question. If you want an answer to that, you need to ask a broker. Because even when I'm practicing law, I do not wear more than one hat. I wear one hat. I don't make conclusions around whether a roof is good or whether the sewer line is strong or whether you can tell how much I know about that. I don't even know what they do with tractors. So there you go. All right, we got a few more minutes. Let's see what we can do here. So you all understand, it's very important when you do that unilateral right to terminate, you want to follow those little 4 things. You want to get your written instruction from your client. You want to go ahead and call the other broker. You want to send them an email informing them that you're going to that you're unconditionally disapproving. And then you send the termination. And the termination really is instructions for escrow. How on earth do we get rid of this money? I get to close my file. What do I do with the money? All right. So, next one. My God. What happened to Alyssa? Did she fall asleep on it? I don't blame you. I mean, I don't know. Okay, so let me explain to you. This is how you write a covenant and a contingency. These are the elements. The first 5 are for a covenant. The first 5 and the next 3, total 8, are for a contingency. All right? And it's what is the subject matter, who's going to do it, how are they going to do it, when are they going to do it, and who's paying for it. All right? And now I'm going to show you some examples of this, but who pays for it is really, really, really important. We had a broker who had made a repair addendum, right? Did a repair addendum, the seller will do all these things. Seller to repair the roof, seller to do the electrical, seller to do the whatever. Seller. There are like 7 things. Seller went ahead and did everything that was asked of him, and then sent the invoice to the buyer's agent. Buyer's agent said, why am I, this is your job. And he goes, oh, no. You asked me to do the work. You didn't ask me to pay the bill. The agent paid the bill. So cover who pays. So it would be like in just with the repair, the repairing the roof, seller at seller's sole expense shall have a licensed bonded roofing contractor repair the roof per an invoice, give them some guideline, by closing or by such and such date, and there you go. That's a covenant. I covered every one. What are we going to do? We're going to repair the roof. Who's going to do it? The seller. How are they going to do it? They're going to hire a licensed bonded roofing contractor. When are they going to do it? On 5 days before closing. And I said seller at seller's sole expense, right? So we covered it all. That is all there is to it. If I made that into a contingency, I would also say that this contingency, because under Oregon law, contingencies are deemed to be for the benefit of both parties unless you tell us otherwise, okay? What that means is that means mutual, what am I thinking of? Mutual way, well, one would be, if it's for both parties, then they both have to waive it. If it's for one party, you only need a unilateral waiver. And because we're running out of time, I'm going to jump ahead and then jump back again in a second. Then you say, how do I give you notice if you didn't satisfy the contingency? It's usually in writing, because we do things in writing. And what are the consequences? The buyer, at his sole benefit, may, at his sole discretion, may terminate the transaction with all earnest money promptly refunded to the buyer. Got it?
You have to put that on there.
We put that on there, and that's how you're writing a contingency. All right.
Addendum is basically the first 5, right? Like the Florida repair addendum, pretty much.
Yeah,
covers
typically a
all-
repair addendum are promises. It's just chock full of promises.
Yeah.
Yep.
And then my next question is, how important is it to add the terminology, if you're just using a regular addendum, all other terms and conditions remain the same? Do you need to add that?
Well, it's at the top of the addendum where it incorporates everything. So it's really, I mean, you're just reiterating. It doesn't hurt to reiterate it by any means, but it's already at the top. If you just write it on a napkin, then you probably want to, because you can you have a binding contract on a napkin? Sure. So, I mean, you only need 5 parts and you got it. So there you are. What was I going to tell you? Oh, for whose benefit? This is what I want to, this is why this is so important. I'll give you this story. What had happened is there was this guy that was going to buy this huge piece of property. I don't know, it was over 100 acres, right? And the guy was going to subdivide it. He's going to build on it. So we got a builder buying this property. So what he did is he made his offer contingent upon him getting county approval that he could subdivide this property. All right? The buyer and seller both agreed that the seller wouldn't be paid until, we would be paid incrementally as each developed parcel closed. Okay? So you build on this one, you close, you build on this one, get paid, you build, paid, paid. We get to closing, and what happens is the poor buyer hasn't gotten his approval from the county yet that he can subdivide. So he says, hey seller, how about an extension of the closing? And the seller says, no, 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 and no. I have people standing in line that want to buy this property for a lot more than you're willing to pay. So, sorry buddy, see ya. And he says, whoa, 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 wait a minute. What I'll do is I'll waive my contingency and I will go ahead and assume the risk of knowing that I can subdivide this property. I still want to buy it. And he said, too bad for you, said the seller. And the seller goes ahead and sells it to someone else. Buyer number 1 comes back and sues the seller for specific performance. Okay? For it wanting to force him to sell the property to him. Does the buyer get the property?
Did the buyer put something in writing saying he wanted out?
The bilateral.
Yeah, I mean, he put it in writing, it doesn't matter. Yeah, he said,
Whose benefit it was to know that they got county approval, so the seller said, we didn't get county approval, that was for my benefit, and goodbye, and selling.
see, that's what the buyer is saying, that county approval was for me only. The seller is saying, no, no, that's for the benefit of both of us, because it's the whole transaction. The court ruled in favor of the seller, saying because the seller was being paid incrementally as every developed parcel closed, that contingency was for both. When the buyer sent his unilateral waiver, had no effect, absolutely none. And so when you say it's for someone's benefit, literally all you have to say is this is what this contingency is for, the buyer's sole benefit or the seller's sole benefit. That's as hard as the language is. There's nothing difficult about it. So, in honor of time, because I want you to know you have, and I can show it to you quickly if you'd like. You have a number of contingencies in your sale agreement, and the one that is the inspection clause is a great contingency. Okay, and what I did, let's say if you go to the next one, I made a short version of it, right? I mean, you know how long that Hummer is. I mean, that's kind of and it says, at buyer's expense, the buyer may have the property inspected by one or more licensed professionals of buyer's choice. The buyer shall have 10 business days after the buyer and seller have signed and accepted this agreement to complete all inspections and negotiations. Unless a written agreement has already been reached with seller regarding buyer's requested repairs, the buyer may notify the seller in writing of buyer's unconditional disapproval of the property, with all earnest money deposits promptly refunded, and this transaction shall be terminated. So, what is the subject matter of that contingency? Somebody tell me. What are we talking about?
Inspections.
Yeah, so click on that one for us, Alyssa. There's the answer. Okay, next question is, who is going to arrange for the inspection? Buyer, so click on that one. How are we going to complete the task? Who's going to do it? Professional inspectors, right? So licensed professionals, so click again, Lisa. Well, okay, we jump forward. The buyer's going to do it. He's going to, one more. Licensed professionals, okay? When will the inspections be done? 10 business days. Click again. Who's going to pay for it? Buyer. All right. We're going through the list. For whose benefit is the contingency? It's for the buyer, and we don't actually say it's for the buyer's sole benefit, but clearly because the buyer has unconditional disapproval rights, it's got to be for him, right? Okay? And then how do we notify somebody if they haven't satisfied the contingency? We do it in writing. And what happened? One more. Keep going, Alyssa. And what happens? What are the consequences? There you go. Wasn't that fun? Now you have a template. Okay, so let's go to, just terrify you for a moment. How am I doing? Hey, I'm talking pretty fast. Okay, let's go to the next one. All right, these are real. Never fails to amaze me. Okay, it says the seller to have roof repaired to obtain a 3 to 5 year certification. What is that? You only got two choices. It's either a covenant or a contingency. What is it? It's got to be a covenant. There's no magic language in there, right? Okay, so we got a promise that the seller is going to have the roof repaired and get a 3 to 5 year certification, right? Okay, so what was the story around this is there was this faulty roof, and there was an estimate that was made that we can take care of the entire roof for $7,000, or we can patch repair it and take care of the dry rot in certain sections for $1,500. Okay, the buyer said, I don't want to freak out the seller, I'll do the $1,500 thing. So the seller goes ahead and has his roofing contractor go in, he repairs that portion of the roof, but doesn't do any of the dry rot. He just goes over it, all right? So he's now put the roof over the rotten dry rot, all right. Now, of course, they find this out, and they're not terribly happy about that whole thing. And so the question is, does this actually protect the buyer? Okay, so first thing, this is just a lousy. First thing is, the covenant, what is the subject matter of this thing? Roof repair and the certification, right? Who's going to do it? Seller. How are they going to do it? Not a clue. When are they going to do it? Not a clue. Who pays for it? Not a clue. All right, so now we have a problem where we're going, okay, don't know exactly what to do with that. The other thing I wanted to bring to your attention is that 3 to 5 certification, what's the value of that? Zero. Zero. Absolutely zero. It's an opinion. It's zero. If you had a warranty, that would be different. But yeah, there you go. All right. Let's do another one. We have a short sale, and I don't even know how many short sales we have anymore. I've always wanted this to be over, and it's like this bad dream that just keeps me. Oh man, I hate these things. But anyway, I haven't seen one in a while. This says that the seller has credited the buyer at closing $3,559 toward the buyer's closing costs and prepays. What is that, supposedly? That's a covenant, because most of them are. That's a covenant. Okay. And what is the inherent problem with that sentence? There are two, actually.
What's a CCPP?
Oh, that's closing costs and
I
prepays.
mean, that would be my problem if I read it out there. Can you spell that out?
Well, you can spell that out. I got lazy.
The bank's not gonna go for it.
Yeah.
The bank is not gonna.
Well, the problem is the seller can't even perform.
Right.
In a short sale, a seller cannot go ahead and contribute any money. Because the lender's going to say, look, you didn't give me all the money. You're asking me to accept less than you owe me. And now you're paying this Yahoo buyer? Come on, give the money to me. So number one, the seller can't even perform. Number two, you can't write lender to credit the buyer because the lender's not a party to the contract. So what you want to do is this thing should actually be a contingency, because it would be something to the effect that the seller, it's contingent on the seller obtaining from the lender an agreement to credit the buyer the money. And then if he can't get that agreement from the lender, the buyer can walk away, because this guy's probably, he may really need that $3,559. it may be a big deal to him. He may not be able to qualify unless he gets that money. So that's where you want, that's something that the buyer would say, if it's really important to get that $3,559, that's where you write the contingency. That's where you say, if you don't get that money, do you still want to close? And he says, I can't close. And we said, well, then it's pretty doggone important. We better make it a contingency because you can walk away. Okay? But that's the inherent problem with that. All right, another one. We got seller to have the septic pump and system inspected, buyer to approve, report in writing. What is that? It's two what? It's two promises, right? It's two promises. The seller is promising to have the septic pump and the system inspected. The buyer is promising to approve the report in writing. Doesn't matter what the report says. The buyer's obligation is to approve it in writing. Okay? Thinking that's probably not what was meant. Clearly, you can have the contingency. The covenant in the front. Seller at seller's sole expense to have the septic pump and the system inspected by a licensed professional, whatever, within X amount of time. Okay? Now you have.
For this too.
Huh?
We have an addendum that's focused on that, right?
Yeah. And but you can have those parts in there, but you can also have, the latter part should be a contingency, right? Isn't the buyer wanting to know that it was done properly? I think so. So that would be, this transaction is contingent upon the buyer having the work done to his satisfaction and approving of the report in writing. Okay? And if he doesn't approve it and it's for his sole benefit and he doesn't like it, he tells the guy in writing and he can terminate and get out. And notice that with a unilateral right to get out, that means you can also waive the contingency. So even if the buyer said it's contingent on me giving this approval and he doesn't like it, he doesn't like the report, but he still wants to buy the property, he can go ahead and waive that contingency and go ahead and buy. All by his own little lonesome. Okay? And that's one of the advantages of a unilateral right. All right. We code another one. Next page. What's that? Oh, you. One more. Oh, keep going. I'm sorry. We should have had that at the bottom. Okay. Next one. And why don't you put both of them on there, and then we have the things on the bottom. So, I gave you a cheater link. All right, we're short on time. Offer is subject to the seller's, I love this. Offer is subject to the seller's proof that a queen-size mattress and box spring can be moved up the stairs, going up and down the basement stairs.
This came from our office, didn't it? Really? We had something like that.
Did you? Yeah. No, actually, I know who did this, but, and I just kind of went, okay, so what is that? Other than, not intelligible, what is it? It's a contingency, right? See the subject to? Okay, so we wrote a contingency. So it's subject to, and so what are we talking about first?
The mattress.
We're talking about the mattress and the box spring going up and down stairs, right? All right, and who's going to do that? The seller, right? And how is he going to do it?
He's going to stuff a mattress.
Well, he's going to provide proof, but in what form? Clearly it'd be a video watching the guys go up and down with this. Something that shows that, yeah, it fits, okay? When is he going to do it? Don't know. Who's paying for it? Don't know. For whose benefit is? For obviously both, because we never said.
Anybody watch the video?
Yeah. And how do you notify him if you're not happy? Not in there. And what are the consequences if it doesn't work? There aren't any. All right? So I wrote this for you just to give you, subject to the seller at the seller's sole expense, providing the buyer with video proof to the buyer's satisfaction within 5 business days of mutual acceptance that the mattress and box springs can be moved to and from the basement. This is for the buyer's sole benefit, and if it's not satisfied within, they can give them notice within 7 business days of mutual acceptance. wait a minute, what is this? Notice in writing within 7 business. Anyway, the long and short of it is you get a notice in writing, and then you would have that, you know, if they can't provide that proof, that he has a right to walk away and get his earnest money. Always both. All right.
But shouldn't we preface this with, he has a right to it, but doesn't mean that the title company is necessarily going to release it.
Exactly. Yeah, that's a problem. Remember that earnest money is always, 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 always in dispute, except under the property disclosure statement if it's exercised within the requisite 5 business days, okay? Always in dispute. Always. So never, ever, ever tell your client that they will get their money back. Because if you say you'll get your earnest money, guess who's writing a check? You just warned it that. Okay, don't do it. Yes, sir.
You know, we talked a little bit about good faith today, you know, acting in good faith.
Yeah.
Let's take the red line provision there and strike the 7 business days trigger. And let's just say that the seller gives the video notification to the buyers. But do you have a recommendation on how much time can transpire to the point at which the buyer has backed out after 7 or 10 days without the latter portion of that provision? At what point you could argue they line up in good faith? So in other words, if I give a buyer the video on a Tuesday, and 15 days later they tell me that it's satisfied.
Right.
You know, I mean, we keep talking about good faith. I'm just curious if you have a recommendation on where it becomes ready.
The only time that it becomes a problem with good faith, he would have the 15 days, he would have until closing, actually, unless the other party relies to his detriment. So if the seller gives the notice to gives the proof to the buyer never gets back and then tries to get out on it, let's say 2 or 3 weeks later, and the seller has literally either incurred costs or lost other buyers or whatever, has relied to his detriment that we are going forward, then we have a problem. The problem is that it is incumbent on the agent to make sure that the client is protected. So this comes back on you, because the question is going to be, why didn't you tie that down so I didn't get in this mess? Because you're the expert, right? You're the one they're relying on. I tell you, one of the things that concerns me greatly about real estate these days is that I think that the concept of agency is literally flown out the window. I don't even think that people understand what it means anymore. There are way too many, and this is something that scares me. I can't imagine people of your quality do this, but you'll probably run into people that do. I had someone come into my office one day, and he said, well, I'm going to tell my buyer to do X. And I said, okay, have you talked to your buyer? And he said, well, not yet. Okay. I said, when was the last time you spoke with your buyer? When was the last time you got together with them? He said, you mean personally? And I said, have you ever met your buyer? Well, no, we've just texted and emailed. Okay. And I said, well, today's your lucky day. Off you go. Because the problem is that 90%, I gave him 3 hours and he did perform. He said, oh, they're not that bad. I said, yeah, whatever. But the problem is that, okay, 90% of all of our communication is visual body language, okay? 10% of it is visual. With a text and an email, you have neither. So my question is, how on earth can you possibly be representing your client? And so, I know that in this day and age, and I'm not against text, well, I'm against texting when I have to litigate something, not litigate, when I have to dispute something, because I can't follow them. I can't tell who said what, when. They're very difficult to follow. So if you're using text and it's something substantive that you're talking about that's important, then you need to copy. I would do Diane a favor. Copy that in bullet points in an email so she can at least follow the thing. So I don't know about you. Texts are just awful. They're just awful. Because you don't know, certain actions precipitate certain responses, right? Well, if I have no timeline, how do I know who said what first? I don't. Then I can't figure out who's staying in it. And all of a sudden, some errant person comes in there that there's Mary in there, and who the heck is Mary? And I don't know who Mary is, and I don't know why Mary's talking. So you want to have that set up. But anyway, that's my little moany groany about that. All right, last one. Do we have one more minute? Do we? Okay. Let's. I think we have one more in here. If I didn't forget. Let's try. Oh yeah. Oh, this was great. Yeah. I just wanted to bring one thing to your attention. It says seller agrees to extend the close of escrow to 4/28/17 in exchange for a per diem credit of $88 for each day from 4/22/17 to the date of closing. My question for you is, and the escrow officer, this is why you always want to have an escrow officer that loves you, because they come and they protect you. Have a good escrow officer. But the question that the escrow officer says, I think I know what you meant, but who's paying the 88? Because it doesn't say, right? And then this agent, who's a wonderful broker, years of experience, highly ethical, very anal about this stuff, terrified to ever hurt anybody's feelings or not do a 100% job, wrote in there in exchange for, and she said, well, I thought that created a contingency. It doesn't. So that's why I want to get back to you. Please use contingent upon or subject to, okay? Just use them, because then you get into the dispute and you know what's going to happen? If there's a dispute, the court says it's a covenant. It's a promise. It's not a contingency. You can't walk away. Okay? So, next one, please. Oh yeah, we go through that. By the way, that's how you write them. Okay, one more. Change that on this. Now, the last thing we have is, once you've written these things, are they actually enforceable? Because it's one thing to write a contingency and covenant. It's another one to actually enforce them. And what I want to do is share with you just a couple situations so that you're kind of clear on how this works and why you should never practice law without a license, okay? The financing one, this is one that came up. This was the Sims case, and what we had is we had a buyer who made an offer, and it was subject on obtaining financing, okay? And it was under certain terms, and I don't really remember the terms, but I'll tell you it was 20-year amortization at 4% interest, okay? And he couldn't get his loan, couldn't qualify for it. So he tells the seller, and he says, I'm sorry I wasn't able to qualify for my loan. I will have to walk away. And the seller says, no problem. I will give you a loan. It was free and clear. I will give you a loan on exactly the same terms and conditions. Now close. Did the buyer have to accept those terms and conditions? Did his financing contingency protect him, or was he subject to that change? Same terms, same conditions, actually even cheaper, because you don't have all the points and all that stuff, right? Does he have to do it?
Well, now we know that, and then the part where it says you have to use the lender that you have the approval from, so.
Well, they could, but more importantly, what you're looking at, I want you to concentrate on whether that financing contingency actually is there to protect them. Can the buyer go back and say, the contract said that I had to qualify for a loan, I wasn't able to qualify for a loan, and no fault of my own, I can walk away according to the contract. Does it hold? And the answer to that was yes, and the court's reasoning around it was that the seller promised in the contract to provide a property free and clear of encumbrances. And owner carry is an encumbrance. And so the buyer was able to walk away. All right? The next one, this was a situation what we're doing is we're representing a buyer in this scenario. It's another case, representing a buyer, and he buys a flag lot. All right? So he has you got the lot, got the big piece of property, and then the seller remains here and the buyer gets up here and the road is down here, right? So part of the deal was that you're going to get an easement for this roadway so he has access. All right? Get to closing and the easement is never created. Okay. So my question for you is, well, the contingency is gone because I mean, it only runs until the end of the transaction, so it's gone. But what about the promise to create that easement? Arguably, we'd certainly say that was material, right? The guy's landlocked. And when you're landlocked, the only way to actually, if they're opposing, if that seller says, I'm not going to give you access to my across my property, is to go through the courts for an easement by necessity. It's full-fledged litigation. We're talking a year at least, okay? So the question is, what happened to that easement? Can the buyer go back and insist that that easement be provided?
Isn't the title company on the hook to make sure if that's in the contract, that was executed?
Well, they're neutral.
But if it's there, they also have to make sure everybody's like doing what they say in the contract, right? That everything that's, no?
They don't interpret it. So we didn't get it. Come on, guys. It's the last one. Tell me. Tell me.
I don't think you need to get it, but it also, but if they closed.
They closed, and now we're coming after closing, and the buyer's going to the seller saying, I want my easement. You promised me an easement. I want my easement. How many say he gets his easement?
Yeah.
How many say he doesn't get his easement? How many fell asleep? All right. The answer is he doesn't get his easement. And the reason he doesn't get his easement is because, remember all the stuff I told you about whether it's a material breach and you can go in and you can sue? There's an exception to that, and this is why I don't want you to practice law without a license. It's called the merger doctrine. And the merger doctrine says that if an issue involves possession, quantity, title, or emblements, crops, things that you would sell for profit, right? That unless you put that language in the deed, the contract merges with the deed. So the contract, all the provisions of the contract go bye-bye. And now the deed controls. So unless the deed said subject to an easement, there is no easement. It merged, and the poor little buyer is out of luck. Okay? Make sense? If I got you thoroughly confused, I'm doing my best. I'm going to do it. All right, I think we're good. You can go to the next slide. I think that's where I say, I wish you a hearty farewell. Do you have any questions? Fell asleep again. Go on. One more. One more. No. Oh! All right, so I do want you to know before I leave that you belong, Janelle has me on retainer here, and I work closely with Diane. And of course, any of your transaction issues that come across, go to Diane. If Diane has a question, she can contact me, and I'm more than happy to help. What I also want you to know is that part of that subscription agreement is that you have access to very, very qualified attorneys in all kinds of areas. Don't think about your own personal transactions, because that goes through the brokerage. But I'm talking about things like when you walk across the street and get hit by that bus. Don't do that. Don't do that. All right. But any other kind of issue that comes up, even if a seller has an issue that it wasn't part of your transaction. So, you know, you have your seller and they said, you know, when I bought this before, they did so and so and so and so, and I now have this problem. That wasn't part of your transaction. So we can help with that. We can help with personal injury. We can help with family law. We can help with if you want to go commit a crime. We can do a lot of stuff, and you get that at a professional courtesy discount. So I'm going to leave some cards here. If that comes up and you have an issue, you know, wills, trusts, I mean, keep going. We got it going. Then we have some very qualified people that can help you.
I think you had us at breaking the law.
Okay, I want to thank you very much, and you guys take care.
If you want a credit hour, make sure to sign the paper. Sign the paper. Sign the paper.
Oh, good morning. You need a pen?
Thank you. Still Diane's.
Right.
this point here, or option one. So that it's in the same. Okay, devil's advocate.
Boom, boom, boom.
I'm gonna put together a list. Make it last for 1:30, go to Tracy's, or is that too
Let me check.
It's too late. We can always go back out. The guys really want to see Tracy, and my afternoon appointment canceled. So.
Nice. Let's go drink some bubbly.
Thank you, Amanda.
Yeah, I'd be happy to drive. You guys put together the list.
Sweet.
Give me rights and lefts. We'll do
All
it.
right. Sounds great.